motions calendar. That's the first of the Gonzalez and Glauberman motions. And is Miss Gonzalez, she's outside, right? Okay. So calling case number 4-1 DRC 21-000-1879. Okay, we're back on record. Okay, so we're calling case number 4. That's the first of these cases I'm going to call this morning on the motions calendar, and that's 1 DRC 21-000-1879, Glauberman Ramil versus Gonzalez. Appearances, please.
Good morning, Your Honor. Jean Marie Orque, representing plaintiffs Stuart Glauberman and Vicky Ramil, who are present this morning.
Good morning.
Good morning, Your Honor. Todd Whitty, representing the same plaintiff.
Good morning.
Hi, Celeste Gonzalez, pro se litigant, defendant.
Okay, good morning. Okay, so I'm hearing the plaintiff's second amended motion for summary judgment. That's the first thing I'm hearing first. I did review the motion, and the plaintiffs have put forth, met all the elements of the case for summary possession. Ms. Gonzalez, the court did review and receive your declaration in opposition to this motion. You say that you have disputed facts, and also the court, there's two things, right? You're familiar with which opposition I'm reading, correct?
Yes,
okay.
I am.
And you also said the case would proceed to trial. Okay, so...
Because it was already, because you had scheduled a trial date for today.
Right, but then they filed their motion, okay?
Okay,
so it doesn't, and let me talk about a motion for summary judgment. A motion for summary judgment is appropriate when there's no disputed issues of material fact. And in this case, and I'm going to give you an opportunity to respond, but the court finds that there's no disputed issues of material fact, okay? Court finds, in order to prove a case for summary possession, the plaintiff must allege and put forth evidence that there was a relationship of landlord and tenant existed, how that tenancy was created, when and how the tenancy was terminated, and that notice to quit was given. Okay, the last time we were here on plaintiff's motion, the court granted that motion, and then Ms. Gonzalez, you filed a motion for reconsideration pointing out that the correct copy of the lease had not been submitted.
Yes, that's correct.
So the court granted your motion for reconsideration, right, because you were correct. And you put forth then that the correct lease that had the HUD statement attached. Well, now the plaintiffs have come forward with the new motion with the correct lease. So there's no disputed issue about what lease is in play. There's no disputed issue about how the tenancy terminated. You say it was terminated on February 28th. And so the court will accept that. The tenancy was terminated on February 28th. There's no other issues of material fact. And the court would note for the record that not only is it relying on this declaration, but all the other papers that you have filed in this case, and I'm going to have to list the cases, your motion for reconsideration, to which you attached many documents,
right,
okay?
Mm-hmm.
And in this case, and also in the case 1 DRC 21-000-2121, and that's the Glauberman KFG Properties versus Gonzalez case.
Yes.
Then also the, trying to think, well, I'll go ahead and state them because we're here today on those other matters. 1 DRC 21-000-4782, Celeste Gonzalez v. G. Todd Whitty. And finally, the 1 DRC 21-000-0319, Gonzalez versus Stuart Glauberman. So the court takes judicial notice of all of the files and pleadings and documents that were filed in those cases, as well as your declaration, because I have read them all. We've been here many, many times, have we not?
Yes.
Okay. So, do you have any evidence in opposition to those material elements of the claim for summary possession?
So I'm just really confused because may I speak freely, Your
Yes.
Honor?
Mhm.
So this is why I am confused, okay, about this whole process. And I am not a rule breaker, okay, first of all. And secondly, I've done my due diligence and I have done my research on the original complaint that was filed on February 21st against me, okay? And I went through that, and there is discrepancies in the original complaint because they marked that my lease was terminated, and it wasn't terminated at that point. So when they filed the complaint at that time, and it says that they marked the box that the lease was terminated, and that you must attach any addendum to the lease when they filed the complaint, and they didn't. What they did was they filed a copy that they sent in the summary judgment, which that's not valid. And the second part of that is my claim is that because they did it on February 21st, that lease technically expired on February 28th, because that's the day that Section 8 stopped making the payment based on the 45-day notice that they sent prior from January 14th. Now, if you're going to do it from February 21st, then that means the lease agreement is binding to Section 8 rules. And in Section 8 rules, it clearly states that you cannot evict a person on Section 8 unless there's for serious infractions. Now, this complaint, as it was brought to me, has to do with HRS 51, 52, and 53. Then and all of a sudden, in the 11th hour, they want to go ahead and talk about the lease all of a sudden. Now that happened after they got the exhibit list on July 23rd, which has a video of all the testimony of how I'm explaining each of the infractions that they have put against me. So I am to understand as a pro se litigant that I am here fighting the charges of all of those three that I just said. And then when the lease became an issue in the summary judgment, I was stuck in quarantine. I didn't understand anything was going on. It was rude against me. And then when I was finally out and I got the paperwork and everything, I said, okay, that's not the correct lease. I went and got it, and I submitted everything. Yes, when I submit paperwork, I'm very thorough, because you know what? I am a pro se litigant. Every time I try to get some type of advice or anything, I get different answers. So I gotta pretty much juggle and see which one, and I come to court and I get in trouble. So I'm not going to apologize for having a lot of paperwork, because I got to cover every single thing, because they can constantly come at me. And so I think that there is still a dispute here, because the complaint itself was not filed properly. And you cannot file something before it even happened. So they filed and said that they had a terminated lease on February 21st, when it didn't terminate until February 28th. And if that's the case, then Section 8 rules apply, because you're still on contract. That's my dispute.
Okay, thank you very much, Ms. Gonzalez. The court does reject those arguments. The court, you have admitted as to what the correct lease is. The fact that it was not the one that was attached to the original complaint doesn't matter anymore.
Okay, Your Honor, inside their summary judgment, they said 60 days. Yes.
I'm going to issue my ruling, okay? Don't interrupt me.
Your Honor, may I add one more thing to my testimony?
No.
Okay.
The correct lease was attached to the motion for summary judgment. Ms. Gonzalez admits that's the lease. Ms. Gonzalez also admits that the lease terminated as of February 28th. Okay, notice has been given. The court grants the motion for summary judgment, enters writ of possession, judgment for possession to issue forthwith. Okay, Ms. Gonzalez, you can go ahead, and if you wish to add anything further.
Yes, I do, because in this second summary judgment, well, I don't know, you already gave a ruling, so do I even have a chance to even speak here? I mean,
if you wish to make anything further for the record, you may do so. I'm not going to change my ruling.
So in the second summary judgment that I was sent, I went and got advice from an attorney, right? And he said, well, it looks like what they're trying to say now is because I didn't correct something within 60 days, and that's part of the summary judgment. So that's why I'm confused, and why does it go back to the lease if that's not what's in the summary judgment?
The lease is terminated, and
Oh, you're basing it on that, even though it's supposed to be extended. I see. Interesting.
Okay.
So basically, anybody who has this kind of issue.
Ms. Gonzalez, I'm not.
Okay.
So that's that on that matter.
Okay.
Okay. The court notes that in this matter, 1 DRC 21-1879, that Ms. Gonzalez has lodged a motion to dismiss this case. Okay, court, given the ruling on the motion for summary judgment, the court is not going to file this motion to dismiss.
Right.
Okay?
So there's no trial today either, right?
There's no trial today, correct.
Okay.
Okay? So, and Sir Edward, I am jumping around because I'm between status, answers, motions, and trial because I'm trying to go for the case. So if you have any questions, let me know. Okay. Ms. Borke, do you have anything further on this matter, 1879?
No, Your Honor. Thank you for your ruling.
Thank you. Okay.
Your Honor, is Mr. Lau here?
He's online.
Oh, okay.
So, and court then will call on number 2 on the motions calendar, and number 5 on the motions calendar. And this is 1 DRC 21-000-2121 Stuart Glauberman by his managing agent, KFG Properties versus Gonzalez.
That's the one with Mr. Lau.
Yeah.
Okay.
Morning, Your Honor. And Law, good afternoon.
Good morning, Mr. Lau. And Ms. Gonzalez, you want to make your appearance, please?
Celeste M. Gonzalez, pro se litigant.
Okay. There are 2 motions on the calendar for today. First, Ms. Gonzalez had filed a motion for recon of the decision regarding possession. The court denies that motion for recon because it's moot at this point. Okay?
I don't understand that.
Okay, you had filed in the 1879 case after those motions for recon on the decisions on possession in 2 cases. Okay?
Right.
And I granted your motion for recon in the other case.
2121.
No, 1879. Was the motion for recon granted in 2121?
Yeah, because what had happened in the court was because originally on August 27th, when the right of possession was granted in the 1879 case, when the 2121 case came up for summary judgment with Mr. Lau, you had asked him what he wanted to do with the case, and then you had mentioned, I don't think you're going to like my answer, so then he decided to withdraw it. So I filed for reconsideration based on the fact that if that one was to go in my favor, which your sentence implied, then the case would have went to trial.
Okay. So that motion for recon, the court does deny that motion for recon today.
So then why was it approved? Oh, so it was approved and now it's denied?
No. Anyway, that's...
Because that's why he filed another summary motion against me.
It's all moot. That one's all moot, Ms.
Okay,
Gonzalez.
I don't understand.
Okay. Now, Mr. Lau, you have filed a motion for summary judgment in this case, and Ms. Gonzalez has filed an affidavit in response to the MSJ.
Right.
Mr. Lau,
Yes, Your Honor.
did we have the right lease attached to your motion?
I filed an amended, a supplemental, affidavit by Mr. Robinson.
Okay, and that, with the corrected lease? Okay,
Yes.
okay. Court grants plaintiff's motion for summary judgment in this matter as well. Court does rely on, and has reviewed Ms. Gonzalez's affidavit in this case, in the 1879 case, in the 4782, the 319, all of the pleadings, all of the documents filed, all of the affidavits and declarations filed by Ms. Gonzalez. Court finds there's no genuine issue of material fact. That Ms. Gonzalez has admitted to what the document is on the lease. She's admitted that the lease terminated as of February 28th and has admitted all the other elements of a cause of action for summary possession. Accordingly, judgment for possession and writ of possession is ordered and effective immediately to issue forthwith.
Thank you, Judge.
Thank you.
So, Your Honor, may I say something on the record
Yes,
for that one?
my apologies. Yes.
Okay, so again, here we go again. Inside the summary judgment, they send all these things and they claim all these reasons for it, right? And they put down that, the son needed to move in because of this reason and that reason and some fire installation and all this other stuff, right? And so I'm thinking, again, as a pro se litigant, okay, so the summary possession is based on all of these and there needs to be some dispute. So I put the dispute in there that installation was already completed. I did a lot of work and a lot of research, to fight this. And now basically everything seems to be just coming on to the fact that the lease was expired. Well, what I'm fighting in these cases is what the complaint was.
So, Ms. Gonzalez, you have alleged claims, okay?
Yeah.
Okay? That's where you're going to argue these things, okay? This is not, the court finds no issue of material fact with respect to the elements required to prove possession. You may have arguments about other things. There's going to be further proceedings on damages, and you may raise those arguments at that time.
Okay, so what I did was I answered the summary judgment.
Right.
And then when I did my research with the Access for Justice, I'm getting information back that if you can create, I'm just trying to tell you what my experiences was, because I don't understand how this could happen if I answered the questions and I prove that there's a dispute.
Okay, and I understand. First of all, you keep referring to having an attorney. Either you have an attorney or you don't.
I don't have an attorney.
But second, I reject your arguments. Okay, the court rejects your arguments.
Okay, well.
Okay, so that's that.
Okay.
All right. Then we have. Let's see.
So what's the move out date, Your Honor?
It's going to be effective immediately.
Oh, so I'm supposed to move today?
I don't know when, but the judgment and writ of possession is effective immediately.
Okay, all right.
Okay.